202.22 talks about an IAS judge and how an IAS judge is permitted to organize their calendars in a civil part in the Supreme and County Court. Now, I'm sure when we do part 208, it's going to be exactly the same, but for now, this is 202. So the first one is a preliminary conference calendar. And the key to that is you're basically going to do preliminary conferences, but you're also going to do like compliance conferences on here, because the only significant factor is that there's no note of issue and no certificate of readiness filed. Next, motion calendar. So motion calendar is obviously for the hearing of motions, and that also includes orders to show cause. So an initial appearance after a judge signs an order to show cause would be scheduled for a return date, and the return date would end up on the motion calendar. So one more thing about the motion calendar, it's irrelevant about the certificate of readiness and note of issue. So motion calendar is just a motion calendar. Hearing motions and orders to show cause go on the motion calendar. Next is the 3. So in my opinion, 3 is the most important calendar on this list, and it's called a general calendar. Once you file a note of issue and certificate of readiness, you get in line for your trial. So after you file the note of issue and certificate of readiness, you would be put on the general calendar. And the definition of a general calendar is a calendar that's, they filed the note of issue and certificate of readiness, but the case it's not like imminent trial ready. Like there is no pretrial conference order yet, or, you know, there's still hope for settlement, but it. Trial date. So a general calendar is basically the order of cases as they become ready for trial. Once you file a note of issue and certificate of readiness, you get in line for your trial. So after you file the note of issue and certificate of readiness, you would be put on the general calendar. And the definition of a general calendar is a calendar that's, they filed the note of issue and certificate of readiness, but the case it's not like imminent trial ready. There is no pretrial conference order yet, or, you know, there's still hope for settlement, but it's on a line to get a trial date, basically. So that's what it says. It's that it's like you filed the note of issue and certificate of. How do you place your case on the fucking calendar? Filing 2 copies of a note of issue with the clerk, that whole shit. What calendar they're talking about is the general calendar. So once you file your note of issue and certificate of readiness, you get removed from like the preliminary conference or conference calendar, and you get put on the general calendar. And the general calendar doesn't mean that like you're picking a jury on your next court date. It just means you're online for, you know, a trial. But basically, cases are scheduled for trial in the order that the note of issue is filed. So the way you get your case on the calendar, and it's the general calendar, is by filing 2 copies of a note of issue with the clerk. Next, pre-trial conference calendar. So it's really important that you don't mix this up with a preliminary conference calendar. So the way that I abbreviate them is a pre-trial conference calendar. I'll abbreviate as PTC. So pre-trial conference, whereas a preliminary conference is just regular PC. And the big difference is that it's a conference that's scheduled after the note of issue and certificate of readiness are filed. So the court will normally take the case off the general calendar, schedule a pre-trial conference, and then it's on the pre-trial conference, the PTC calendar. 5 is the reserve calendar. So the reserve calendar would be where a case is sitting on the general calendar. It's got its note of issue and certificate of readiness has already been filed, but the court is not, for whatever reason, the court does not want to order a pre-trial conference. So no PTC, the case is put on a reserve calendar. 6 is what's called a ready calendar. And the key word to a ready calendar is that trial is imminent. Trial is imminent. So ready calendar, imminent trial. Okay, 7 is a military calendar. And no, this does not mean that there's like a military is a party or something. It means that a necessary witness or a party is in military service, and that either a deposition cannot be taken or a deposition would be inadequate evidence. So that's a military calendar. That's 7. And then last but not least, 8 is continuous calendars. Okay, so 8 is only for a court that's not continuously in session. And you don't have to memorize this one, just read it. It basically just says that when there's a court that's not continually in session, that the cases that are on the calendar in one term will retain their positions in the next term. Again, not really one I think they're going to ask. Okay, so calendar progression. So what is this talking about? So all this says, it's not written very well. It's a little confusing and wordy the way it's written. All it says is that, let's say I'm sitting on the general calendar and I'm first on the general calendar. So then when the calendars move in progression, because let's say somebody settles or there's a trial that starts on the ready calendar, I'm first on the general calendar. I will then move to either the bottom of the pretrial conference calendar or the bottom of the reserve calendar. And then I'll slowly migrate to the top of that calendar. And then when I finally am at the top of the reserve calendar, I will then, when there's an opening on the ready calendar, I will then move to the bottom of the ready calendar. That's all it's saying. And then obviously that it has to have regard to statutory preferences. So if there's like a terminally ill party. Okay, C is call of calendars. And it just says an IS judge can schedule the call of calendars for whenever they deem appropriate. So the judge says, be in at 11, you have to be there at 11. And that specifically says an IS judge. D is trial readiness, or readiness for trial. And what that says is that if the lawyers basically get up there and they announce that they're ready, but the trial court is not available because like someone's ahead of them or they're just not available. Let's say that case that was ahead of them settles at the last minute. Counsel can arrange to be available by telephone to appear on 1 hour's notice. 1 hour's notice to be ready for trial. That's how that works. Or at such other time as the court orders. So this way you don't have like 55 lawyers sitting in the courtroom waiting. Like they can leave and go back to their office and just be ready to show up on 1 hour. They could be there on 1 hour's notice. There's no reason to have 55 lawyers sitting in your courtroom when like the first 54 cases or whatever is going to settle. So that's why that's in there. 1 hour. Don't forget, 1 hour's notice by telephone. Don't forget, 1 hour's notice. Lawyers can arrange to be there on 1 hour's notice by telephone. They may arrange with the court to do that.